Welcome back to Lost Touch channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. I want to start this video by saying that I don't consider myself to be a YouTuber. I'm a real criminal defense attorney that handles real cases in state and federal courts with real consequences. I try to keep my clients out of prison and hold law enforcement accountable. The reason why I post these videos every Wednesday on YouTube is to keep the general public informed about the law. Again, it is done for educational purpose. I hope that next time you have an interaction with our judicial system, you will know a little bit more about the law and how your case will be handled. I also hope that you might call me or talk to your own lawyer about some of the cases you've learned here on the channel. But I also recognize there's plenty of other channels on YouTube that talk about the law. One thing that differentiates me from others is that other channels often have all the gimmicks. They show you the body cam footage, but you really don't learn anything about the case because you don't know how the court actually handled the particular situation and what was the outcome. That is because the people that comment on the videos, the lawyers that run those channels, are often individuals who have never handled a criminal case. And I won't throw any channels under the bus, but if you do just a little bit of research, you will find that some of those lawyers, a vast majority, have never handled a criminal case. So why am I telling you this? Well, last week, when I posted my video on Wednesday, like I always do, I woke up the next morning and I saw that it was going viral. There were tons of comments and the views were going through the roof. I want to thank all of you, the new subscribers, and the people who have been watching my channel for years. I know that it takes a special breed of a person to go through the case the old school way by looking at the facts, analyzing them, reading the case without any of the gimmicks, without the body cam footage or any other things related to the case. Simply looking at what the court said about the particular situation. So again, thank you so much for subscribing, sharing my channel with your friends and family, and so on. So today, let's discuss the automobile exception. As you already know, if you've been paying attention to my channel, the Fourth Amendment protects you against unreasonable searches and seizures. And generally speaking, officers need to have a warrant before they conduct a search. But of course, exceptions apply, and one of those exceptions is the automobile exception. If the officers have probable cause to believe that the vehicle contains contraband, they can search the vehicle without a warrant. But of course, police often enough exaggerates the facts that don't amount to probable cause. And today we're going to look at the Ninth Circuit case that deals exactly with that situation, where the officer makes a claim that doesn't really amount to probable cause. We're also going to look at impoundment. Just because the individual gets arrested doesn't mean that the officers can automatically impound the vehicle and search it before impoundment. But before we go on, I want to thank you again for watching my channel, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of my merch. Thanks for watching.
Quick message from Lawstash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lawstash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lawstash YouTube page. That's LAWSTACHE.
Today we'll be discussing a Ninth Circuit case, United States v. Cervantes, and it deals with the automobile exception and impoundment. Because the automobile exception requires the officers to develop probable cause before they search the vehicle, the case is factually heavy because the court has to determine whether what transpired amounted to probable cause. So first, let me give you some factual background. On March 25th, 2009, Detective Todd Hankel of the Los Angeles Police Department and his team of narcotic detectives and officers were conducting surveillance of a suspected narcotics stash house in Pacoima, California. Around 1:20 p.m., Hankel observed an unidentified male arrive at and enter the suspected stash house. A few minutes later, the unidentified male left the suspected stash house with a large white box and placed the box inside his truck. Detective Hankel learned from his police radio that the unidentified male drove to a nearby street and pulled over to the curb. Hankel heard over the police radio that the unidentified male got out of his truck with the white box, walked over to a white GMC Envoy, and handed the white box to the second unknown male, who was later identified as Cervantes. 20 minutes later, Hankel heard over his radio that Cervantes drove his GMC Envoy to a nearby liquor store. Hankel observed Cervantes exit the liquor store with a purchase, getting inside his GMC Envoy and driving away. Shortly thereafter, Hankel heard over his radio that Cervantes drove on Interstate 5 and exit at San Fernando Mission Road. At this point, Hankel observed Cervantes through a residential neighborhood. It was Hankel's belief that Cervantes did not take a direct route to his location. Hankel concluded that this was a counter-surveillance driving technique that included Cervantes was engaging in narcotics trafficking. At this point, according to Hankel, probable cause existed to believe that Cervantes was engaging in drug trafficking and had a large quantity of narcotics in his possession. Hankel, however, did not attempt to stop Cervantes. At approximately 2 p.m., Hankel heard over the police radio that Cervantes drove to a residence on Polk Street. Hankel drove to the residence and saw Cervantes' GMC Envoy parked on the street. Hankel heard over the radio that Cervantes remained inside the GMC Envoy for approximately 5 minutes, got out empty-handed, and went inside the unknown residence. At 5:30 p.m., Hankel heard over his police radio that Cervantes and an unknown male left the residence on Polk Street in a white BMW. 45 minutes later, Hankel heard that Cervantes and the unknown male returned in the white BMW to the residence on Polk Street. After about 1 hour, Cervantes returned to his GMC Envoy and went to the rear hatch area of the vehicle. A few minutes later, Hankel heard that Cervantes left the Polk Street residence in the GMC Envoy. At this point, Hankel asked a marked police unit to develop a lawful reason to conduct a traffic stop. But wait a second, I thought that he already had probable cause to stop the vehicle. Why is he asking this other agents, the other police officers, to create a lawful reason to stop? I thought he already had the probable cause. But anyways, in response to Hankel's request, Officer Sanchez and Officer Colley stopped Cervantes' GMC Envoy after the vehicle failed to come to a complete stop behind the limit line at the intersection. Cervantes cleared the intersection and, according to the Officer Colley, pulled to the curb approximately when the officer stopped him. During the traffic stop, Sanchez and Colley asked Cervantes for his license, registration, and proof of insurance. Cervantes looked around, but was unable to locate any of the documents. Colley asked Cervantes to step out of the car and performed a pat-down search for weapons. Cervantes told Officer Sanchez that he had been arrested previously for driving under the influence, his license had been taken away, and that he was currently attending classes. After finding no record of driver's license under the name Cervantes provided, officers concluded that Cervantes was driving without a license and decided to impound and search his vehicle. During the inventory search of the vehicle, Officer Cooley located the white card box in the rear passenger seat. A search of the box revealed that it contained approximately 2 kilograms of cocaine. After the discovery of cocaine, the officers arrested Cervantes for unlawfully transporting narcotics. Once Cervantes was transported to a police station, booked, and positively identified, Department of Motor Vehicles records confirmed that he did in fact have a valid driver's license. Cervantes moved to suppress the cocaine found in GMC Envoy, claiming that the officer searched his vehicle in violation of the Fourth Amendment. Now remember, the Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before conducting a search. But of course exceptions apply, and one of those exceptions is called automobile exception. I have previously published a multi-part series of videos here on YouTube dealing with vehicular stops and searches of the vehicle without the warrant. I believe it is a 4-part series, and one of those parts deals specifically with the automobile exception. So after you watch this video, I ask you to go back and click on the link that I will publish below. It will take you to that particular series. It's very interesting. It gives more of an overview of all of the exceptions that deal with vehicular stops. But today, we're focusing on the automobile exception. If the officers have probable cause to believe that the vehicle contains contraband, they can search the vehicle without a warrant. The government claims in this case that the probable cause arose because of 2 facts. Number 1, that the white box came from a suspected narcotics stash house. And number 2, that Mr. Cervantes did not take a direct route to his destination. So first, let's look at the stash house. One of the themes which runs through the decisions on the Fourth Amendment probable cause requirement is that when the ultimate probable cause determination is made, whether by a magistrate when a warrant is sought or upon a motion to suppress evidence obtained without a warrant, mere conclusions will not suffice. The court says that Henkel's statements about the stash house amount to nothing more than conclusory assertions. He can't explain to anyone why he thought that the house was a narcotics stash house. Conclusory statement that a building is used as a stash house does not suffice and doesn't become probable cause. We need more. We expect the officers to actually tell the court why they believe something is a stash house, rather than simply calling it a stash house. Second, let's move on and talk about the route that Mr. Cervantes took. Much of what the officer said is that Mr. Cervantes exited the Freeway 5 and went through the residential neighborhood. Henkel said that this was anti-surveillance technique. Instead of going on the freeway all the way to the destination, Mr. Cervantes took the exit and went through the residential neighborhood. But the court says that much of the activity described by Henkel is consistent with perfectly innocent behavior. For example, Henkel notes in his declaration that he heard over his police radio that Cervantes drove to a nearby liquor store and parked in front. He saw Cervantes come out of the liquor store with a purchase, get inside the GMC, and start driving again. While seemingly innocent conduct may carry a different message to a trained officer, it is difficult to imagine what inference a trained officer could draw from this activity, other than Cervantes entered the liquor store and exited with a purchase. In sum, we now know that the officer's statement that the box came from a suspected stash house and Cervantes' driving did not amount to probable cause. And of course, it is only reinforced by the fact that Henkel asked the other 2 officers to develop a reason to stop Mr. Cervantes. At the end of the day, the other 2 officers said that they pulled over the vehicle because Mr. Cervantes went over the white line at the intersection. But of course, if Henkel already had probable cause to stop the vehicle, why did he ask the other 2 officers to develop more reasons to pull over the vehicle? Well, that's because the court says there was never any probable cause to stop or search the vehicle under the automobile exception. Now let's move on and see if the community caretaking exception saves the day for the officers. Under the community caretaking exceptions, officers can of course impound the vehicle, and before impoundment, they can search the vehicle. So could they find the drugs? because they were impounding the vehicle? Under the community caretaking exception, police officers may impound the vehicle that jeopardize public safety and the efficient movement of vehicular traffic. Warrantless inventory searches of vehicles are lawful only if conducted pursuant to a standard police procedures that are aimed at protecting the owner's property and at protecting the police from the owner charging them with having stolen, lost, or damaged his property. Additionally, a vehicle can be impounded under California Vehicular Code 22651 only if impoundment serves some community caretaking functions. None of the officers in this case could testify that Mr. Cervantes illegally parked, or his vehicle was impeding traffic, or that his vehicle in the residential neighborhood was susceptible to theft or vandalism. In fact, the officers testified that Mr. Cervantes parked properly in the residential neighborhood. And the fact that the California law or the police policy allows the officers to impound the vehicle does not mean that they should always do it. It is only when there's a community caretaking taking place that the officers are allowed to impound the vehicle. And here, without that purpose, the impoundment was not proper. I hope you've learned a little bit more about the automobile exception and the community caretaking exception. And here the officers could not use neither of these to justify a search of the vehicle, which means that all of the items that were found inside the vehicle have to be suppressed and cannot be used against Mr. Cervantes in court, which means the case of transporting narcotics would be dropped. I once again want to thank you for watching me on YouTube, hitting that subscribe button, and sharing my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.